Good day, Crime Talk aficionados. We have a great show for you today. First, did Richard Allen mean what he said about killing Abigail Williams and Libby German, or was he just joshing around? How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? In the Young Thug trial, we'll talk about it. A guy in Arizona cooks his daughter in a scorching hot car while he's in playing video games. A third person has been charged for dismembering a 75-year-old man. And, this lawyer risked it all for an inmate. And the sheriff in the Sonia Massey case admits his deputy was wrong and asks for forgiveness. We got video of a Chick-fil-A worker fighting off a robber and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell so you receive notifications of when we go live or put up new content. And yes, you can listen to us on any of your favorite podcasting apps as well. Just another option to get your Crime Talk. Oh, and don't remember, you can go to Roku TV, you can go to Rumble, you can go to Twitch, you can go to Twitter, and you can go to Facebook as well. Yes, we are everywhere. All right. Before we get to the docket, little story today. Yes, why was the court canceled? Well, a defendant supposedly, I've received it from reliable sources, so I'll take it as true. A defendant in Denver District Court today has his trial on the 5th floor. Now, why they would build a criminal courthouse with an atrium that you can look down into that overlooks the security below? Well, apparently that defendant jumped, resulting in his death. And he apparently hit two people, one a witness in a case, not his case, and a security worker there at the courthouse. So needless to say, I was a little surprised when everybody was standing outside of the courthouse today, but we waited about an hour and then they finally closed the court today. First time that that has happened in my career. I've had clients that had standoffs that resulted in their death. But definitely a first for me today. But like I said, I'm a little surprised this hasn't happened sooner, because the way the building was designed is that there's a big atrium where you can look down, like I said, some 5 stories. And the only thing stopping you is some plexiglass, whatever the requirement is for it to be. And I always thought that there would be a fight, like after a big sentencing, like in a homicide case where the families, where they all show up with their T-shirts, kind of like my Rex Heuermann T-shirt behind me here. I don't know if you can see that. Anyway, so I always figured there'd be a fight between the families and somebody would be thrown off the balcony or the ledge. But today was the first time in the, 10, 12 years this new courthouse has been open. So can't make this stuff up, ladies and gentlemen. All right, let's go ahead and get to the docket. Let's open the record for August 1st of 2024. And first on the docket, did Richard Allen really mean those horrible things that he said about Abigail Williams and Libby German? If those statements come in, that's going to be bad for him. Ooh. Well, let's take a look and see what happened. As you know, the motions hearing for Richard Allen are being held before the Judge Frances C. Gull, and she's heard arguments on Richard Allen's mental health and whether a jury can hear about the alleged multiple confessions Allen has made while he was in solitary confinement in prison. Now, he's being held in a prison, not a county jail, because of his security. That's why he was there. So while he was there, he's in this protective custody. They think he's on a suicide watch. Limited resources, they say, hey, let's get a couple of inmates to sit there and monitor him and take down notes of whatever you say. So the Indiana State Police stated that they listened to all of Allen's phone calls from prison, and he started confessing to the murders in April of 2023 while on the phone with his family. His family initially didn't believe him and told him They're messing with you. They're messing with your mind. Well, the detective said that Mr. Allen confessed to the Delphi murder more than 60 times with specific details about what he did and why he did it, making statements like, "I killed those two girls." The detectives also told the judge that Mr. Allen at one point said he committed the murders with a box cutter that he tossed into a CVS dumpster. Now, Mr. Allen's attorneys have obviously been very aggressive in their defense of Mr. Allen, and they argue that the confessions coincide with the decline in his mental health. They claim that Mr. Allen was coerced into confessing while in the prison facility. Now, the prosecutors say, hey, you can't believe those defense claims that he was somehow tortured, beaten down, mind games played on him in any way, because the inmates and the correctional officers weren't actors, and they didn't force Mr. Allen to confess. They were basically just note takers, observers. And so the prosecutor says that Mr. Allen was never interrogated and that his confessions, both verbal and written, were of his own accord. Because of Mr. Allen's voluntary confessions, the prosecution has argued that the motions to suppress should be thrown out altogether. So, like I said, Mr. Allen, he's obviously been arrested for the Delphi murders. He was arrested on October 28th in 2022 for, like I said, the murders of 13-year-old Abigail Williams and 14-year-old Libby German on the Monon High Bridge there in Delphi, Indiana. Now, Allen's trial was already been pushed back multiple times. The most recent trial date was in May, but that got pushed back until October. But the case was pushed back to October after the defense said they needed more time for the case. The trial is now scheduled to begin October 14th and is expected to go for 1 month. Now, this is probably one of the most common questions that I get as a defense attorney. Hey, I was arrested and the police didn't ask me any questions. Okay, that's good. Well, weren't they supposed to read me my Miranda rights? No, because they didn't interrogate you. You only have to be advised of your Miranda rights if you're in custody. Now, certainly Mr. Allen was in custody, but they have to be interrogating you. If they're sitting outside of your cell taking copious notes of what you're babbling, that is not an interrogation. Those statements are more than likely coming in, and the jury's going to have to decide whether they're true. The defense is going to have to present evidence at trial that his mental state was so bad, he was the ramblings of a madman, and therefore you shouldn't believe it. The jury's going to have to give it the weight that it deserves. All right? So, going back to Miranda, it's only if you're in custody and they're asking you questions that Miranda becomes applicable. And it has to be a government agent. If not, it is just an admission by a party opponent, which is non-hearsay and comes in. Next on the docket, the Young Thug trial. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? Well, we're going to have to wait and see, but I think we're getting close. All right. We have talked about this. We here at CrimeTalk, I think we need to do it. I think we need to do a wall of shame of some of the worst judges ever. And the first one, we'd have to go way back in time for Judge Alito, who did the O.J. Simpson trial. And we've got lots of bad judges to add to that wall of shame. And the judge in the Young Thug trial, yeah, he should go too. What a complete fiasco. So, as you know, the Young Thug trial is now facing yet another ethical test due to another round of alleged judicial and prosecutorial misconduct in the racketeering prosecution against Young Thug, a.k.a. Jeffrey Young Williams. And, of course, a bunch of other cohorts that he hangs out with. They're all in trial. Yesterday, there are new allegations of a second secret ex parte meeting between since-recused Fulton County Superior Court Judge Earl D. Glanville and two prosecutors in charge of the long-running case, and they were revealed in a supplemental defense motion that was filed yesterday. Now, these new allegations come some 2 weeks after Glanville was removed from the case over another secret ex parte meeting between himself and the deputy district attorney handling the case. That would be Adrian Love and Simone Hilton. Now, the judge's controversial time at the helm of the nearly 2-year-long proceeding was marked by frequent allegations that the court was acting like a prosecution team member, during which Mr. Glanville was accused of displaying a decided animus for the defense and the defense attorneys. Whew, haven't we all been there? And that's a problem, Judge. If you want to, be a prosecutor again, come have a seat over here, but just get off the bench. Start calling balls and strikes. Anyway, the secret meeting that forms the basis of this new allegation was actually the first such secret meeting, and it occurred back on June 7th, according to the motion filed by the defense. The secret meeting that previously also blew up the trajectory of the case occurred on June 10th. Now, in each instant, the secret meeting concerned the testimony of the state's star witness, a guy by the name of Kenneth Lil Woody, Mr. Copeland, Kenneth Lil Woody Copeland, who reluctantly took the stand only after he was held in contempt and threatened with substantial jail time by both the state and the court. Well, there's a new transcript, and it shows that Love and Hilton, the prosecutors, discussed Copeland's former attorney, a guy by the name of John Melnick, in a disparaging fashion after Copeland pleaded the Fifth Amendment and was thrown in jail. Well, Judge Glanville responds by telling the prosecutors he understands their concerns, but he's limited to his remedies that he has before him, before pivoting and invoking into the specter of outside agitators somehow wreaking havoc on this case. Well, the filings characterize the outside agitators' claim as Glanville making outrageous allegations against the members of the defense team. The filing goes on to say that such outrageous conversations is evidence that the trial is being conducted unfairly. It is not a fair trial in an ex parte meeting, Glanville, Love, and Hilton gossip, as they gossip over nearly 13 pages of transcripts about attorneys Shart, Melnick, and Steele. It's not a fair trial when it is an ex parte meeting, Glanville, Love, and Hilton assassinate the characters of the attorneys, saying they're not acting in the best interest of their clients. The filings repeatedly accuse the court of bias permeating the trial in other ways, including the allegations that one of the prosecutors lied to the court about an email she received from Copeland's former attorney. In sum, the defense argues the bias has been overwhelming to the point that the case should be dismissed with prejudice. They state, how many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? The defense motion continues. This case is like an old house that the present honorable judge is tasked with renovating, but every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. The Herculean effort of the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and the retrial barred due to prosecutorial and judicial misconduct that goaded Kendrick into the present motion. I'm going to agree. First, why was the judge having ex parte communications with the prosecutors and the defense not present? This Judge Glanville should be removed. I mean, this is like Judge 101 type of information that he should know. And he did it because he thought he could get away with it, because he's the chief judge. Who's going to question him, right? And then we find out it wasn't once, but it was twice. The judge didn't report it. And more importantly, the prosecutors haven't admitted it. This is getting into a situation where the prosecutors should have at minimum said there was a conversation, reported that to the defense so that they could put it on the record and try to explain why they didn't do it. They didn't do it. I hate to throw the E word around, but I'm very concerned as it relates to the prosecutor's conduct in this particular case. And if they get it dismissed, kind of like the Alec Baldwin case for doing shady stuff, so be it. And guess who do you have to blame? Not the defense, but the prosecutor for playing fast and loose with the rules. And in this case, it seems like the court is somewhat complicit in what is taking place. I say dismiss the case. That's my position. We'll see what happens. I know. We'll just have to wait and see what happens. I know people say that. Oh my gosh. But it's true. All right, next on the docket. This dad basically cooked his 2-year-old in a car while he was in playing video games. A 2-year-old died of heat exposure inside a hot car after her father left her in the driveway on a scorching hot day, and that was the result of the autopsy. So Parker Schultz was found dead in the blue 2023 Honda Acura SUV about 4:15 on July 9th outside the family home in North Tucson, Arizona. Her father, Christopher Schultz, was charged with second-degree murder and child abuse after police found that he had left her in the car for a nap for 3 hours. The Pima County medical examiner said that the temperatures inside the car were probably just about 108.9 degrees Fahrenheit when the first responders arrived. Now, the autopsy conducted on July 10th confirmed that Parker died from environmental heat exposures, and the report listed the manner of death as an accident. Now, Schultz told police that he left Parker in her car seat inside the car with the engine running and the air conditioning on because he didn't want to wake her up. He claimed she was there for less than an hour after they arrived home, but guess what? There's video footage that revealed it was more than 3 hours in the direct sunlight, according to the criminal complaint filed with the courts. Now, this guy's wife, Erica Schultz, is a doctor at a hospital where Parker was declared deceased and arrived home about 4:08 p.m. and asked where her daughter was when they then found her in the car. As Parker was rushed to the hospital, she texted her husband saying, "I told you to stop leaving them in the car. How many times have I told you?" She later added, "We've lost her. She was perfect." The dad, the husband, replied, "Babe, I'm sorry. How could I do this? I killed our baby. This can't be real." Schultz, two other children, aged 9 and 5, told the police that the father regularly left all 3 of the kids in the car alone. Now, the kids told police that Schultz got distracted by playing his game and putting his food away. The PlayStation and other electronics were taken away as evidence for the police. Now, the father of the 3 told the police he left the air conditioning in the Acura running, but knew it would automatically shut off after about 30 minutes based upon previous experiences. Now, Schultz told police he got home about 2:30, but surveillance footage shows that he got home about 12:53 in the afternoon. The camera also showed Schultz was never went outside to check on Parker until his wife arrived home when she asked where was the kid. Minutes later, they found Parker unresponsive in the back of the car and called 911. Now, Erica Schultz is an anesthesiologist, called her daughter's death a big mistake, and has begged the judge to reconsider holding her husband in custody until the next hearing. The judge upheld the doctor's request, agreeing to release him until the next hearing on Thursday so he could start the grieving process with his relatives. Yeah. Anyway, the wife explained that it would be better so that she could bury her daughter within the upcoming week so that they can go through this whole process with the family together. She feels that this is just a big mistake and that it doesn't represent who her true husband is. Anyway, they want their father around so they don't have to endure another loss. Mixed emotions about this one, ladies and gentlemen. I mean, I don't know if you want to get into unique theories of prosecution. If the mom knew that the dad had did it, but let him watch the kids again, knowing that she left him in the car. Ooh, another unique theory of prosecution, ladies and gentlemen. See how those unique prosecution theories get a little weird when you try to expand those? Yeah, I know. Yep, we keep talking about those people in Michigan, the Crumleys, right? Should have known. This guy's done it before. She knew about it. I don't know. Maybe we should charge the doctor as well. Or was it an accident that the prosecutor should exercise some prosecutorial discretion here and say it was, in fact, an accident, a reckless accident, for sure. But this guy's going to have to live with the fact that he killed his kid. Tough one, isn't it, ladies and gentlemen? See, it's always those cases when that unique theories of prosecution come about. I don't know. I think it's child abuse resulting in death. We had a judge here once. She was a judge. I think she may have even been the chief judge, but don't hold me to that at the time. And she was babysitting her niece and was in the car. Somebody called the police and confronted it. And of course she says, like, don't you know who I am? And they said, we don't care, but you left the kid in the car. But she was asleep and she wasn't harmed or injured, but she was still prosecuted for that particular case. Everybody knows you don't leave your kid in the car, particularly in freaking Arizona in the summer. I think this guy needs some consequences. I really do. Sorry for his loss. I'm sure he will beat himself beat himself up the rest of his days. But the reality of it is, ladies and gentlemen, wow, he should be prosecuted. Next on the docket, a third person has been indicted for the dismembering of a 75-year-old man. That's right. This third person was indicted for sending texts from the phone of the man whose legs were found in a different neighborhood earlier this year. So it was previously reported that the leg of 75-year-old Edgar Kelter Sr. of Kettingburg, Ohio, was found in Trotwood back on April 22nd of this year. And the rest of the remains were found in a storage unit in the same area. Needless to say, his legs were gone. Anyway, in May, Keiter's son, Edgar Keiter Jr., was formally charged with the gross abuse of a corpse, tampering with evidence, and theft. And then in early July, a woman by the name of Amanda Reef, who was identified as Keiter Jr.'s girlfriend, was also indicted with complicity to commit tampering with evidence and complicity to commit gross abuse of a corpse. Now, a third person has been formally charged in relationship to the death of Mr. Keiter Sr., Tegan Keiter. He was arrested on July 18th on tampering with evidence charges. He was indicted on 4 counts of tampering with evidence in the Montgomery County Court of Common Pleas. Now, Tegan was accused of sending text messages and making calls from Keiter Sr.'s phone after his death, making it seem like he was still alive. Anyway, the detectives interviewed Tegan on July 15th when he admitted that he had talked to Keiter Jr. about trying to make Keiter Sr. put Tegan on his will, according to the statement of fact in court records. Anyway, Keiter Jr. reportedly told Tegan he would kill Keiter Sr. if Tegan was not put on the will. Tegan admitted to going to Keiter Sr.'s house, seeing him dead on the floor with a knife through his chest. Tegan also admitted to sending text messages and making the calls from the senior's phone. He also admitted to deleting messages from April 12th from his own phone. Now, Tegan is in custody at the Montgomery County Jail with no bond. He is scheduled to appear in court again for advisement of charges. Next, an attorney thought that it was worth risking it all over somebody in custody. So, an attorney from Massachusetts has been arrested after police say that she tried to smuggle drug-infused paper into a guy that she knew at a Rhode Island federal prison. Please meet Teresa M. DeJosephs. She was taken into custody just the other day and charged with 1 count of possession with intent to distribute a controlled substance, providing a prohibited object to an inmate, and making false statements. So a woman by the name of Hannassa Stedford, she's about 21 years old, and 2 men incarcerated at the Donald W. Wyatt Detention Facility in Rhode Island, where Sean D. Hart and Samuel Douglas are also accused of participating in the alleged drug smuggling scheme. All 3 are facing 1 count of the conspiracy to possess, intent to distribute a controlled substance, and 1 count of providing a prohibited object to an inmate. Now, according to the United States Attorney's Office for the District of Rhode Island, DeJosephs, on July 9th, 2023, used her credentials as an attorney to meet with Hart in a visiting room that had no plexiglass screen between the inmate and the visitor, as is often used by attorneys to conduct legal work with their clients. Well, DeJosephs allegedly filled out paperwork claiming to be Hart's attorney of record. Anyway, a correctional officer on duty at the time of DeJoseph's visit said that the lawyer was slouching and acting very suspicious and was watching the correctional officer's movements. It was soon discovered that DeJosephs did not represent Hart in any of his ongoing criminal or civil matters, and that she had been sending Hart personal photos of herself and placing sports bets on his behalf. Soon after that visit, DeJoseph's contact visitation privileges with Hart were terminated, and DeJosephs allegedly responded by emailing Wyatt's warden stating that she was repulsed by allegations of potential misconduct. She said that an unidentified opposing party had served Hart with many documents and that there were very complicated applicable rules and procedures and case law that must be explained to him in person for his very complicated legal matters. Well, in September of 2023, DeJoseph allegedly sent the warden another email claiming that during her previous visit, she had been subjected to an illegal search because a correctional officer had checked the paperwork she had brought with her to review. Each piece of paper methodically and slowly included that she described as very sensitive material and attorney work product. How dare she? Anyway, DeJoseph was permitted to resume contact visits with Hart in late November of 2023, according to the federal indictment. And then on December 1st of 2023, DeJoseph visited Mr. Hart again at approximately 4:20 p.m. And when a correctional officer reviewed the materials DeJoseph indicated she wanted to bring into the visit with Mr. Hart, the officer observed multiple pieces of paper that appeared as though they had been wet and then dried. And they seemed to be a little thicker than the normal paper and a little discolored. Well, based upon the correctional officer's experience identifying drugs in a correctional setting, he confiscated those 10 pieces of paper from lawyer DeJoseph as potential synthetic marijuana, also known as K2. The 10 pieces of paper were seized by the Wyatt's Professional Standardized Unit and placed in a secure unit where they were collected by the FBI on December 4th of 2023, because the FBI conducts all investigations of crimes at a federal Bureau of Prison facility. Investigators state that the synthetic marijuana is often soaked into paper, which is then torn into smaller pieces and sold throughout the prison, and a single piece of paper has an estimated prison value of some $4,000. Now, when asked about the papers, attorney DeJoseph allegedly told the correctional officers that she had picked the sheets up from a printer and had just brought them there to the jail. Anyway, the confiscated paper tested positive for residue of multiple Schedule I controlled substances, and then investigators said they learned that Douglas had ordered his girlfriend, Miss Stedford, to deliver the drug-soaked papers to DeJoseph so she could then bring them to Mr. Hart when they met. Oh, those pesky phone calls, they're always monitored. And when questioned about the papers by the federal agents several weeks later, attorney DeJoseph allegedly claimed that she went to Staples earlier in the day to print some material, and she believed the paperwork was added to her files when she was there at the Staples store. Obviously, that's what happened, right? But when pressed, guess what? She was unable to recall which Staples that she visited, and she couldn't produce any sort of receipt. Ooh, pesky questioning, lawyer DeJoseph. Haven't you ever watched CrimeTalk? Lawyer. Apparently not. Anyway, Ms. DeJoseph and Mr. Stedford were scheduled to make their first court appearances on Tuesday. Now, Ms. DeJoseph was released after posting a $10,000 unsecured bond. That's called a PR bond in the federal system. Risked it all for this dude that's an inmate. Risked it all. What do we say, ladies and gentlemen? I tell everybody, every one of my attorneys, never met a client worth going to jail for, and I've never met anybody that would been paid enough to jeopardize my law license. And this lady did it all in one. She is certainly not going to have a law license in the near future for this guy that was in on both criminal and civil matters. Unbelievable. Next, the sheriff has no excuses. That's right. The Illinois sheriff whose deputy shot Sonia Massey, the unarmed black woman who called 911 for help in her Springfield home. Well, that sheriff apologized to the community during a gathering Monday night, saying, "I offer up no excuses." Now, Sheriff Jack Campbell faced a hostile crowd of more than 500 people at the Union Baptist Church in a meeting facilitated by the Community Relations Service of the Justice Department. Now, a somewhat and oftentimes emotional sheriff said, "I ask Miss Massey and her family for my forgiveness. I offer up no excuse. What I do is offer our attempt to do better. As you may recall, Deputy Sean Grayson is charged with first-degree murder, aggravated battery with a firearm, and official misconduct in the death of Miss Massey back on July 6. Body-worn camera video released on July 22nd shows that inside her home, Miss Massey moved a pan of hot water from the stove. Grayson apparently feared that that hot water would be thrown at him. He fired 3 times, striking Miss Massey once in the face, despite having several non-lethal options. Now, Mr. Grayson has pled not guilty. And on Tuesday, the union representing the sheriff's department said that it would not pursue a grievance demanding that the deputy be reinstated and a return of lost wages and benefits. Ooh, you know it's bad when your union won't come and help you. That's just undefensible. And the unions can defend anybody for any police misconduct, regardless of how blatant it is, even on body cam videos. So you know it's got to be bad. Obviously, we'll give former Deputy Grayson, the presumption of innocence, but I think the video speaks for itself. He should not have shot Miss Massey. He should not have. Now, the sheriff's office there is going to be writing a big check, and unfortunately, it's going to go to Attorney Crump, who just always seems to show up on these things and makes it a racial thing. And obviously, the family needs to be compensated. But oftentimes these cases, these cities so overpay. They so overpay. We'll just leave it at that. Next, take a look at this video of a Chick-fil-A worker fighting off a robbery. So security footage from the restaurant on Stone Mountain Highway in Gwinnett County, Georgia, shows the unidentified employee arguing with a masked armed robber who pointed the gun at his head. Do you think you could do that? Anyway, the gunman then demanded the employee open a safe in the manager's office about 4:30 a.m. on July 1st. In the very moments, the suspect allegedly warned the worker that if he didn't open the safe, he was going to die. The worker then could be seen pushing and wrestling with the assailant, forcing the suspect to lose his grip on the weapon, which falls to the floor as the employee manages to pull the man's mask off, sunglasses, and his dark-colored hat. Like a little cockroach, once he's exposed to the light, they scatter. Anyway, the suspect, who has since been identified as 51-year-old Tommy Lee Williams, he tried to fight back and was seen trying to punch and kick the delivery driver at various times during the fight. But police said he fled the restaurant empty-handed before officers arrived on the scene. The driver told officers he was working that night when the suspect smashed the drive-through window with a rock and climbed into the kitchen area. He then made the chilling threat, prompting the employee to fight him off. As he told the officer, he didn't know the combination to the safe. Anyway, investigators eventually identified the vehicle they believed the suspect used to arrive at the Chick-fil-A and obviously fled in as well. Police then issued a warrant charging Williams with armed robbery, aggravated assault, burglary in the second degree, kidnapping, possession of a firearm during the commission of a crime, possession of a firearm by a convicted felon, and criminal damage to property in the second degree. What? A felon had a firearm? No, that's not supposed to happen. It's against the law. Anyway, Mr. Williams was finally arrested with the assistance of the United States Marshals. Somehow I bet that not only will he get state charges, he's going to get a federal weapon by previous offender in the federal system as well, because he's going to get about 5 years minimum on that. And finally today, well, actually, before we go on to that, also it's worth noting, good advice that I tell people: don't submit, fight like hell, and it worked out well for this guy in this particular situation. And finally today, our dumb criminal of the day. Okay, like I said, I know it gets old, almost cliche-ish, but you can't make this stuff up, okay? In a million years, I never would have thought about doing this, all right? But please meet Jacqueline Gozinski. It's Gozzzzynski. Gozinski. That's what we're going with, ladies and gentlemen. Well, Jacqueline Gozinski and her 3 children were hanging photos in a Florida residence when the defendant used an electric screw gun and screwed a nail into the victim's left side buttocks. I guess they were just playing around. Anyway, when questioned by the police about the incident, Gozinski reportedly said that when the girls walked past her, she asked the victim, who is 12 years old, about getting screwed in the ass. Gozinski, cops charged, placed the screw gun on the girl's left buttocks cheek and pressed down on the trigger, driving the screw into her buttocks. The screw, which left a visible mark, was stuck in the girl's body until it was ultimately taken out. Now, Gozinski was arrested by the St. Petersburg police and charged with felony child abuse. She's being held in the county jail for $25,000 bond, and obviously has been ordered to have no contact with the victim while she's in custody, as well as when she gets out of custody. So apparently Gozinski recently moved into this small 3-bedroom apartment, a rental home in St. Petersburg. That's why she was hanging these picture frames. Anyway, what can you say, ladies and gentlemen? I don't know. Really. What do you say to somebody like that? What defense could you possibly have to say, let me put a screw in your butt cheek? Okay, I know people say, Scott, you shouldn't say that because dumb means lots of different things and you're disparaging people. But that's just dumb. That's dumb. And Miss Gozinski, you're dumb. Hate to break it to you. That's just dumb. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. We do appreciate you taking the time to, and we hope that you enjoyed the show. We'll see you next time. And remember, yes, the Constitution matters.